Good evening. This is John Milburn for Laws 13010, Evidence and Proof, and this is week 6 of Term 3, 2018. Thank you very much for those that are online, ready to join us for this live session. So by now, you've completed your first assessment task. Thank you very much for everyone for participating. We have a couple of people that failed to turn up, but the vast bulk of you have completed the task. And I completed that task of assessing just a couple of hours ago. So we'll provide some results to you in the near future. Just firstly, some comments in relation to that first assessment. Now, the idea of the assessment was to provide a practical flavour to the work that we're reading about from a theoretical perspective. And it's important to understand in a better way how evidence and proof in theory translates to practice. So the brief exposure that you've had now in examination or cross-examination provides you with the opportunity to think about how a court case is run from the evidentiary perspective. And one of the aims of the exercise was for you to be flexible in terms of the way in which the procedure was to be adopted. And that changes, of course, and requires you to listen actively to the answers that were provided by the witness. And I can say that most of you listened very carefully and picked up on some clues. But during the course of reflection on some of the responses, it was clear that people hadn't always listened to the material that was said. And sometimes when you're in the process of eliciting or challenging evidence, one statement, one word might give you an opportunity to go off, for want of a better term, onto a tangent that might assist you one way or the other. So listening actively is a skill that's certainly important in evidence and proof, and it's a skill that's important throughout any of your legal studies or any practice that you might adopt in law. There is a risk when involved in undertaking evidence in chief or cross-examination of asking one question too many. Let me give you an example, and some of you fell into this trap. Let's assume that you're the prosecutor and you're seeking to elicit information from a witness that the course or the unit code for evidence and proof is Laws 13010. Now, that might be one of 20 things that you wish to establish. And you've got your checklist. These are the things that I need to obtain from this witness. And number one is confirmation evidence that the unit code for evidence and proof is Laws 13010. Let's assume that we take a snapshot now of the process of the evidence being obtained from this witness. I'll play both parts. The examiner says, "Are you enrolled in evidence and proof?" Yes. What is the unit code for evidence and proof? Laws 13010. Are you involved in any other units? Yes. At Central Queensland University? Yes. What are those units? Administrative law and jurisprudence. What is the unit code for administrative law? I don't know. What is the unit code for jurisprudence? I don't know. But the unit code for evidence and proof is Laws 13010. Now I'm not so sure. Can you see from that little brief excerpt the issue of asking one question too many? Why would you ask the question that you've already received the right answer to? And for those of you that were prosecuting, I suspect those of you that did it well, and there were quite a few who did it well, that you had a list of things that you wanted to elicit. These are the material facts that you wish to elicit. You're listening carefully for the response, and once you've got the answer, tick it off and move on. You don't go back, because it can only lead to trouble. When you've got 100% success, why risk it by asking again? Conversely, for defence, one of the problems that we saw was asking a question that led to material where you didn't want to go. And one of those things was in the case of asking about information that had been gleaned from external sources. Always dangerous, dangerous territory. Irrelevant because it's asking questions that are not material to the facts and do not advance the cause. So those people that ventured into asking questions about what somebody might have heard, very dangerous territory and irrelevant, pointless, but may lead to a response that really hurts you. So those in defence who may have wished to challenge the fact that this person, the witness, believed that the person had a criminal history just from looking at them, go into dangerous territory if you ask a question along these lines. So, you believe that you have the ability to determine that someone has a criminal history just by looking at them. Well, yes, I do. On what basis do you say that? Well, it's my strong suspicion. And did you get any support for this strong suspicion that you have? Yes, I did. The police told me that he's got a criminal history. Bang, horrible answer for defence. Inadmissible, of course, but I can see what you're trying to do. You're trying to challenge and seek some external verification for this so-called suspicion, but don't go there. Now, those of you that found the exercise quite easy probably did pretty well. And I say that because it's a bit like going into a maze. Now, if you can picture a maze where there's one correct channel, there's one correct path. You follow that path, you don't go down any side roads that are incorrect or lead you into trouble, and suddenly, after you've started, you end up and you're finished. You think, well, that was pretty easy. However, if you go into the maze and you take a wrong turn, that may be something that you can recover from fairly quickly, or it may lead you into a world of hurt. And it may be then very difficult to navigate back to a situation where you're back on track. And so the point that I'm trying to make is this, that because, well, 2 points really, because it was relatively easy, then that doesn't necessarily mean you did poorly. It might mean, in fact, quite the opposite, that you did well. And the second is this, that you need to prepare very carefully in terms of the evidence that you seek to adduce by having a clear map, a clear plan in your mind. Now, you normally supplement that with questions. And I'm sure that there's not one of you in the class that was able to successfully run through your list of questions from 1 to whatever it was, 70. I'll bet there's not one of you that can honestly say, yes, it all ran to plan. If you were, please let me know, because that would be a real surprise. So you've got to have some questions ready to go, but you need a great deal of flexibility. And the way in which I like to think of it is this, that you have the key points, maybe 10 points, and it might be a word or a phrase, and that's something that you wish to achieve. And then on the side, you have your list of questions, which is your aid from a practical perspective in order to achieve those 10 things. When I had to, this is not meant to be a war story, just an example, and others may well have completely different practices. But when I'm cross-examining or examining, I'll do so with a pen in hand, typically, if I'm working off paper, and I will normally have, I'll tick things off, and I'll try to do that. Subtly, or cross them through. So if I achieve a milestone, a mark, and that's done, cross it off, don't go there again. And likewise, so you've got to have that central map, and then you supplement that with your questions. So does that make sense from a theoretical perspective? So the questions are a necessary aid to ultimately achieving what you wish to do, and that is to adduce 1, 2, 3, 4, 10 pieces of key evidence. All right, so I'll have the results to you shortly. There'll be no written feedback on this occasion. The feedback that I provided on the day is the feedback that we have for the exercise. So are there any questions, comments? Now, oh yes, so Michael has looked at the 10 commandments for cross-examining witnesses, which I provided in Introduction to Law. Was that Irving Younger? Did I provide that in evidence?
You gave it to intro a year ago.
Oh, okay, in intro. Did I put it into the Moodle website for evidence? I'll do that. It's really good.
Perfect, especially for that asking one question too many.
Oh, one question too many? Yes, okay, very good. I'll do that because it's a lot of fun. So if you haven't looked at Irving Younger, please do so. It's readily available on YouTube, but I'll provide the link. Keith says, asked that question, do you think that a ready alternative, please, to attacking a witness credibility without putting your position at risk? Yeah, when you're attacking credit, that's always a dangerous area, because if you attack credit, then depending on the type of credit that we're talking, it may come back to bite you, but you do need to attack credit in the sense of trying to cast doubt over the witness's evidence that's been provided. And usually the way that we do that for those that are cross-examining is to have the witness concede the possibility that it may not have been the way that the witness says. And with defence, we've got that great advantage where we're just simply looking for the possibility. So is it possible? Is it feasible? Are you entirely certain? Those sorts of phrases we see often in the context of cross-examination. So you don't necessarily need to get a complete reversal. It's not like on TV where suddenly there's the gotcha question, the gotcha moment where the witness says, you're right, I'm completely wrong. Usually it's far more subtle than that. And there's a human dynamic, isn't there, that people, if they make a statement, they tend to want to hold their ground and defend their position. So sometimes the best you can do, and all you really need to do, is to chip away at the edges and create that bit of doubt, so that ultimately it builds up to the point where you can say, you really can't rely upon what this witness says. Marcus says there's a written version of this for prosecution, probably best to Google, and it's called the 10 Commandments in relation to cross-examination, I think. All right. So any questions, comments? Yes, Marcus?
Evidence in Chief, John?
Yes.
Sorry, so the one by Ernest is for the cross-examination, and the other one, there's a 10 Commandments for Evidence in Chief. But it's not it's only a written version.
Oh, okay. So only a written version for the prosecution counterpart.
Yes. I found it, had a brief read. It's not as good. I don't think it's good as the one provided by Ernest.
Yeah. I mean, his delivery is just so brilliant that it's very entertaining.
True.
So a big plug. If you haven't looked at that video, we'll try and access it, but please do. All right. Now, the second assessment is practical in nature once again. If you haven't already sourced the movie that you wish to analyse, please do so. Do so soon. It's not the sort of exercise you want to rush and do at the last moment. So do try and source the movie or movies. Watch them both. They're both entertaining, and answer the questions, giving yourself time to think about it, because you need to mull over these things. Does anyone have any problems in accessing the source material? And I think there was a question about, can you use a later version? Yeah, probably, provided it has the same content, and I suspect it would do. Okay, so now the third assessment will be the examination. That's an entirely different thing. So the first two assessments are very practical in nature, where we're applying the rules. The examination will be very much theoretical, along the lines of those examinations that we've had in the past for evidence and proof. I think from memory, it's 8 questions and you need to answer all 8 of them. I know that it's very difficult to face an exam where every part of the assessment, every part of the curriculum is accessible, but that's what we have in this situation. So there's no bailout question, there's no option for you to take a different route. Having said that, the questions are pretty straightforward, they're pretty easy. In preparing for the examination, I'd urge you to consider the video that I prepared sometime last year, which I think I called Level 3 Preparation for Examination and Short Window Take-Home Papers. And what I urge you to do in that video is prepare in a very particular way. And I'll go further and say there is a Level 4, not that I mentioned it in the video. Level 4 is to take Level 3 and then apply it not just to this unit, but have it available for you as a tool that you use in other assessments, other units, and in your career generally. I won't say any more than that. I'll leave you to watch the video and make your own assessment and prepare in that manner. Now, before we started the whole exercise around the first assessment, we were talking about direct and circumstantial evidence. And the case of Plomp and the Queen, 1963, 110 CLR 234, is really a very important case. And if you read that case, consider the circumstances, you might realise that it's fairly topical in relation to a case that's quite newsworthy at the moment in relation to an alleged historical murder charge. And Plomp is all about the way in which circumstantial evidence might be used to mount not only a charge, but also secure a conviction. It was a murder case, a murder charge, where the woman involved, being the wife of the accused, drowned off the Gold Coast beach in 1960, the early 60s. The woman who died was a strong swimmer. The surf conditions were normal, and there was no real explanation by the husband as to how this might have occurred. But there were a number of things which went to build a strong circumstantial case in relation to this conviction. So it's what we call a circumstantial case. It's a case that's built around circumstantial evidence of the rope variety as opposed to the chain variety. Now, do you know what I mean by the distinction between the rope variety of circumstantial evidence and the chain variety? Does anyone wish to tell me what the difference is?
Doesn't
Yes,
the
Marcus.
ropes all intertwine and the chains linked together? Similar to that?
Yes, that's exactly the mental picture that you need to adopt. And why would that be relevant to discussions around circumstantial evidence? The difference between the rope being intertwined pieces of or strands and a chain being a continuous factor or a continuous chain. Logical reasoning, yes. So where's the logic and the reasoning in relation to this analogy? Nicole's got it. If one link in the chain is broken, it can fall apart, but the rope doesn't rely only on one strand. So if one strand in a circumstantial case of the rope variety fails, it's not necessarily fatal to the circumstantial case. But if we have the type of evidence which is chain related, then as was discussed in the case of Shepherd against the Queen, 1990 170 CLR 573, Shepherd against the Queen, the evidence in the link situation would be regarded as indispensable. In other words, each one of the key parts of the evidential case would be described as indispensable links in a chain of reasoning towards the inference of guilt. So that was the High Court in Shepherd against the Queen. I'm not giving you a specific exam hint here, but I'll just say that that's the sort of case that we tend to put into the examinations at the end of the year, explain the difference between the rope and the link, the chain theories of circumstantial evidence, and provide us with an example, that type of thing. If you want a recent example, have a look at the Crown against Francis, 2017 QCA 182. Now, when I say the Crown against, that's code for the way it's written is RV Francis. But we're third year, so we all know that, don't we? So in the Crown against Francis, 2017 QCA 182, the defendant was charged with attempted murder and previous bodily harm with intent to cause grievous bodily harm. He entered a plea of guilty to the second charge, contested the first charge of attempted murder. And the arguments that you might consider in that case are all around the importance of circumstantial evidence and the inferences that might be gained from that. So I think that's worthwhile having a look at the case. It certainly discusses the Chamberlain case and what's become a Chamberlain direction. The Chamberlain, of course, is Lindy Chamberlain's case, and that is Chamberlain against the Queen, number 2, 1984, 153, CLR 521. And it also discusses Shepherd against the Queen, particularly in the context of a Chamberlain direction. And what we mean by a Chamberlain direction is this, that when we're dealing with a circumstantial case, it's no more than an amplification of the rule, says the High Court in relation to a Chamberlain direction, then the prosecution must prove its case beyond reasonable doubt. In many cases involving substantial circumstantial evidence, it's a helpful direction, the Chamberlain direction, but in other cases where circumstantial evidence is slight, it might be more confusing than helpful. So do see if you can obtain the Chamberlain direction, and do refer to the Shepherd case that I've mentioned earlier, the Chamberlain case itself, and the recent example against the Crown and Francis. The issue of primary and secondary evidence is also important. The best evidence comes from the primary evidence that's available, and there is, and you would have heard about this in different units, the best evidence rule might be something to consider as well. Right, let's move on to oral evidence, and the first assessment was really all about oral evidence. Firstly, when considering oral evidence, we need to consider the question of who is competent to give evidence and who is compellable to give evidence. So where would we find the law relating to the competence and compellability of witnesses to give evidence? Just off the top of your head, where's the first? What's that? Sorry, Angela?
The Queensland Evidence Act?
Exactly, yes. And you'd also look at the Commonwealth legislation for Commonwealth jurisdictions. Section 9, thank you, Angela, so, and Marcus got it as well. Section 9 of the Evidence Act, Queensland, provides for the general presumption of competence. Every person, including a child, is presumed to be competent to give evidence in a proceedings and is competent to give evidence in a proceeding on oath. So when we read Section 9, we see that there's the general proposition. Doesn't matter who you are or your age, the presumption is you can come to court and you are competent to give evidence. But it's interesting that there's a distinction drawn between competent to give evidence in a proceeding and competent on the one hand, and competent to give evidence in a proceeding on oath as a separate thing. So it draws the reader to the distinction between simply giving evidence as opposed to giving evidence on oath. And there is a distinction almost always when we think about someone giving evidence, we equate that to a person giving evidence on oath. But it is possible for some people to give evidence even though they're not under oath. There is the exception to the general rule, section 9A, and this is the only exception. And that is, under Queensland law, the general rule of competence to testify is subject to the person being able to give an intelligible account of events to which the testimony would relate. So it's not suggested that the evidence in question be given on oath, but there must be an intelligible ability. Now, Michael has raised a very good point, and that is, I just said a moment ago that every person, including a child, is presumed to be competent to give evidence in a proceeding. But we should colour that and make a statement that there is a further requirement that people be of age to do so, in the sense that they have to be able to give an intelligible account. And Michael says, it seems to be fundamentally unfair that a child is competent to give evidence but not competent to commit an offence if they're under the age of 10. And I think there's a lot to be said for that. That if the law presumes that a person cannot commit a criminal offence if they're age 9, can we really rely upon them to give evidence in proceedings if they are the same age? The law says, on its face, yes, but there is subject to that exception that I mentioned earlier. So you need to have a good working knowledge of Section 9 and need to consider the various subparts or the various additional sections, 9A, 9B, 9C, and 9D. And also think about the possible implications from the criminal code. In that regard, when we're talking about evidence, think about section 632 of the criminal code. And this is an important evidentiary rule. And it basically says this, section 632 of the code. It prohibits any suggestion being made to a jury that the law regards any class of person as an unreliable witness. It wasn't always that way. The judge can make some make other statements that might go to that, but for example, it may have been at one stage that a person who made a complaint long after the event occurred as being an unreliable witness, but we can't say that now. What does happen though, from a practical perspective, is that the court may, the defence may ask for, and the court may give, what's called a Longman direction. Longman direction, and that's after the case. It's referred to in Robinson and the Queen. And it's basically a direction to say where you have a complaint that was given well after the event in question, it may have prejudiced the defence, who could have otherwise dealt with the matter and brought to bear evidence at the time that may have better explained the circumstance or negated the allegations that were made. So there is that attempt to balance the situation in terms of fairness issues. So do have a look at section 632 of the Criminal Code. Do look at Longman directions and have them accessible. Can anyone tell me where you might find the Longman direction? Or Statements Bench Book. Thank you, Marcus. And not only will you find the Longman direction, but you'll find the commentary that goes with it. That is the statement that the court would, the judge would typically make to a jury in giving the Longman direction, and it's supplemented by case law. So when you're doing evidence and proof, bench books, one of the first places you should look, I think. for statements to better explain the principles that we're talking about. Now, I mentioned this concept of a witness having to give an intelligible account of events. Now, let's consider a few cases. They're in your textbook. In R against Williams, 1989, 1 Queensland Report 601, a 10-year-old boy who was almost illiterate was allowed to give unsworn testimony because the judge was satisfied he understood that he'd be in trouble if he didn't tell the truth. So the judge didn't put him through the process of having to go on oath, but allowed him to give this unsworn testimony after the judge tested him and said, yeah, I'm satisfied. He knows he'll be in trouble if he doesn't tell the truth. And that's an example. That case is an example of the usual situation. 99.9% of the time, people give evidence under oath, or they're giving their sworn evidence in any event, as opposed to the unsworn testimony. Now, contrast that to another case, confusingly also R against Williams. It happens sometimes. This is a decision unreported, 26 April 1991, from the Queensland Court of Appeal. And in that case, an 8-year-old boy was deemed to be incompetent to testify when he could not inform the court of his home address or the name of his teacher. So you can see what happens. The judge will undertake a private investigation. I'm sorry, when I say private, an investigation in the absence of the jury to determine whether or not this person can actually give an intelligible account of events. And finally, a case of R against Drover. It's a district court decision of now retired District Court Judge Morley from 1990. It's also unreported. It's Drover. And the trial judge refused to allow evidence of a young girl who, in the judge's words, and I like this quote, had all the qualities of a young actress, reciting what she knew by recitation, not by recollection. All right. And see you later, Michael. All the best for Christmas. So, the court must explain in these circumstances the duty of speaking the truth. And there are ramifications if the court doesn't do that. So, for example, in Chalmers' case, Crown against Chalmers, 2013 to QDR 175, the Court of Appeal overturned a conviction. The trial judge had not complied with obligations in sections 9B2 or 9B3, which meant the boy's evidence was not received according to law. And also think about the case of R against BBR, 2010, 1 QDR 546. The entire trial was quashed because the trial judge failed to give the complainant the explanation required under that same section 9B3 before she gave her unsworn evidence. Okay, so do we get the picture now about this issue of general competence and the exceptions that relate to the giving of evidence and the exceptions about competency, and this distinction between giving evidence that is sworn as opposed to evidence that is unsworn? All good? Now, the Commonwealth position, have a look at section 12, have a look at section 13. 12 deals with competence and compellability. Section 13 deals with competence and the lack of capacity. And a person is not competent if the person does not have capacity to understand a question, to give an answer that can be understood, and, in addition, the incapacity cannot be overcome. So in the Commonwealth sphere, it's a bit different because this additional requirement to do something to overcome the deficiencies if possible. And it's only if you can't overcome these difficulties that the person then becomes not competent to provide the evidence. So sections 12 and section 13. But do also look, and this is in the Commonwealth Act, look at sections 30 and 31, which provide examples of the assistance that the court might provide to someone to enable them to overcome these difficulties. So sections 30 and 31 supplement sections 12 and 13. Now, during your reading, you would have read about this difference between tactical burden to testify and call witnesses or lead other evidence. Now, when we're talking about evidence, there's a basic distinction between that which relates to the civil and that which relates to the criminal. So please bear that in mind, particularly when we get to the point of documentary evidence. In terms of civil proceedings, back to the Queensland legislation, have a look at sections 6 and 7, which relate to civil, and then pay particular note of a very well-known and often quoted case of Jones and Dunkel, which led to the rule in Jones and Dunkel. Now, theoretically, the rule only applies in civil cases, but from a practical perspective, there's a fair chunk of Jones and Dunkel that applies in criminal cases as well. We'll try and explain that. Now, can I just ask a quick poll? This is just to get you tapping on the keyboards. Have you read about Jones and Dunkel? Has everyone read, yes or no? And you can be honest. We're getting a couple of no's. We're getting a few no's. And that's okay. I appreciate you being honest. And the reason I'm asking a little bit, a brief idea. The reason I'm stressing it now, and I've asked you to answer that question, and thank you for being honest, is you must know the rule in Jones and Dunkel. Again, it's the sort of thing that crops up in exams. Yes, Sarah, did you have a question?
The 1959 case?
Yes, exactly.
Yeah.
1959, 101 CLR 298. The case itself is actually quite interesting. And what I can say is that this case really talks about the tactical burden of leading evidence to rebut adverse evidence that would otherwise provide an adverse inference. And it also deals with this best evidence rule. So here's what happened in Jones and Dunkel. See what you think. I'm sorry. Now, Jones was the widow of a truck driver. The truck driver was killed in a head-on collision with another truck, and that truck was driven by Dunkel. Dunkel didn't give evidence in the trial. It's a civil trial. And there was no other evidence available to show how the collision occurred. So the question arose as to whether what should the court make of the fact that Dunkel, who's being sued and could have gone into the witness box and explained what happened, chose not to do so. What do you think? Is the court entitled to say, well, because you said nothing, we suspect that what you would have said would have been against your interest, so therefore we're going to hold it against you? Elise says it was an adverse inference that the court might have made. The rule says yes, says Marcus, but is it fair to say, well, unless you tell us what happened, we're going to assume that you were at fault?
Yeah, aren't you innocent until proven guilty, though? Like, I realise that's criminal, but,
yes.
you know.
Very good distinction. And Marcus just came in at the same time and said, yes, but there is no presumption of innocence in civil cases. And that's the key distinction, isn't it?
So there's a presumption of guilt then?
Not of guilt, but the Jones and Dunkel decision basically says this, and you can tell that in this case Jones won, Dunkel lost. And the court said, rightly or wrongly, this is Windermere, I have in mind that the defendant could have come here today and given evidence. am I entitled, this is the judge's own words in the case, am I entitled to regard his failure to do so as a weakness in his case? And the proper answer to the question is yes. Menzies looked at it a little more in detail, but I do like what Windermere said. It was really nice and simple. Justice Menzies, and I'll paraphrase, said the proper direction in these circumstances should make three things clear. Number one, the absence of the defendant as a witness cannot be used to make up any deficiency in the plaintiff's evidence. Number one. Number two, but an arbiter of fact, judge or jury, can more readily accept evidence that might have been contradicted by the defendant if the defendant gave evidence, if the defendant had chosen to give evidence. So number three, so where an inference is open to the arbiter of fact from the facts provided by direct evidence, and the question is whether it should be drawn, the fact that the defendant chose not to give evidence is properly considered in favour of drawing the inference. So Justice Menzies has explained it quite technically, but I do like the quote of Justice Windermere. It's much simpler and really gets to the point. So, in the context of compellability in civil cases, what we're saying is that whilst a plaintiff can't compel the defendant to get into the witness box, Jones and Dunkel creates this consequence, doesn't it? It creates a consequence for a defendant who fails to testify or to call a material witness to testify. Therefore, from a practical perspective, the party is tactically compelled to testify. If they choose not to, the plaintiff will say, Your Honour, we ask the arbiter of fact to draw an adverse inference against the defendant, given the defendant's failure to testify and give evidence or call evidence in circumstances where he, she, or they could have done so. Does that make sense? So that's the rule in Jones and Dunkel. But don't take my word on it. Please do some research. Make sure that you have, to level 3 standard, prepared a response ready to write in an examination if you're called upon to explain and illustrate the rule in Jones and Dunkel. All good? These are not, I should say, these are not necessarily direct exam hints. Yes, Travis?
John, that rule is only in civil cases, though, isn't it?
It is. It is. It is, but, and we'll get on to the but now. All right, so criminal accused. Now, as Marcus and others quite rightly identify, whilst there is no presumption of innocence in civil cases, there is, of course, this absolute privilege, this absolute presumption of innocence. And therefore, at law, there is no way the defendant is compellable to give evidence. So can the rule in Jones and Dunkel penalise a defendant who fails to testify, given that the presumption is that of innocence and the rule of law says that the accused is not compellable to give evidence and no adverse inference should be drawn against them failing to do so? In Queensland, there is actually no absolute ban on a trial judge or even Crown Counsel making adverse comment to a jury regarding the failure of an accused to go into the witness box and testify. So what I'm saying by that statement might fly in the face of everything that you've known in your study of law for the last 3 years. In the Commonwealth, it's different. In the Commonwealth jurisdiction, Section 20, subsection 2 of the Evidence Act provides that Crown Counsel may not comment on the failure of an accused to go into the witness box, although the trial judge may do so. So it's slightly watered down in the Commonwealth sphere. All right, so what do we need to know about this Jones and Dunkel type principle when it applies to criminal cases in Queensland. You need to know Weiss and Steiner against the Queen, and you need to know as a party and a few other cases on the way through. So we'll start with Weiss and Steiner. 1993, 178, CLR 217. The High Court gave the common law authority on whether a trial judge might instruct a jury that they may draw an adverse inference against an accused who decided not to testify. Here's what happened in Weiss and Steiner. You've got two people in a boat. The boat disappears without trace. Weiss and Steiner, one of the two on the boat, is later found in sole possession of the vessel, and Weiss and Steiner was on board the vessel when the deceased went missing and was last seen alive. Weiss and Steiner said, I'm not going to give evidence. So you've got a situation where you're out at sea, two people on a boat, one person comes back, the boat comes back, people say, what happened to the victim? I'm not saying anything. So it's kind of the same principle in Jones and Dunkel, isn't it? It's that principle where a person fails to testify in circumstances where there's no other evidence, and surely that person would be able to let us know and illuminate what happened. After Weiss and Steiner, and the court said, yes, you can draw an adverse inference against the accused even though they failed to testify in that circumstance. I guess it was a pretty brave case. But after Weiss and Steiner, Crown Counsel would regularly ask for a Weiss and Steiner direction to a jury. But it's very dangerous territory, much more dangerous territory in criminal cases than in civil cases. An example, R against Peel, P-E-E-L, 1999 to QDR 400. QDR, of course, is the Queensland Reports. Peel was charged with firebombing a car using a Molotov cocktail. Fingerprints of Peel, nobody else, found on the bottle. He decided, I'm not going to take part in a record of interview and I'm not going to give evidence. Now, the trial judge did give a Weiss and Steiner direction, and that was on the basis that only the accused can explain how his fingerprints were on the bottle, and he chose not to do so. But the Court of Appeal said the trial judge should not have done that, and the court held that the direction was not appropriate because the bottle in question was very common, and these bottles are in many households, and therefore they could not safely conclude that the accused must have had knowledge of how his fingerprints came to be on that bottle and chose not to reveal it. It's kind of different in the facts to Weiss and Steiner. Weiss and Steiner is just so unique in that sense. So Peel, the court started to have some concerns about it. The real change comes with as a party against the Queen. So this is the other key case in this area. As a party against the Queen, 2001, CLR 50, and in that case, the court said in a criminal proceeding, the accused is not bound to give evidence, so we know that. The Crown must prove its case beyond reasonable doubt. We know that. And the court said the observations in Jones and Dunkel should not be applied in criminal cases without really considering those key aspects very importantly. So in as a party, the High Court said, if an accused doesn't give evidence, the judge should warn the jury that the accused's silence is not evidence against the accused, and it does not constitute an admission, and it can't be used to fill gaps in the evidence of the prosecution. So what we find now is an as-a-party comment is normal, and a Weissensteiner direction is really for those kind of unique cases where the accused had certain material information and chose to withhold it from the court. So Weissensteiner is the exception, the as-a-party comment is the rule. But the Weissensteiner direction is still valid in many circumstances. As an example, a more recent example, have a look at R against Kadour, K-A-D-D-O-U-R, 2018 QCA 37. Now, this was an interesting case. It was to do with the supply of dangerous drugs, and I'll invite you to look at that. What you will notice is that there's reference in that case, and increasingly often in cases now, to the Baden-Clay decision. So be aware of Baden-Clay's legal citation. I'm sure you're all aware of the facts. R against Baden-Clay, 2016, 258, CLR 308. And Baden-Clay is relevant in the context of this Weissensteiner direction and as a party comment as well. Sometimes what happens is that a person will, a complainant will provide a preliminary statement to police, but then not support that at trial. And we see that quite often in domestic violence matters, where on the night, the victim of the domestic violence provides a lot of detail to the police about what happened, and then 3 months later at the trial says, no, none of that happened, it was completely different. So we do see that a lot. The complainant made a preliminary statement, then doesn't support that, and maybe even becomes hostile. For a not so recent decision, but have a look at R against Cooper, 2007, 175, Australian Criminal Reports 94. In that case, Cooper was convicted of assaulting his de facto spouse G in their home. There were no witnesses other than G herself. And at trial, as I mentioned, as is quite typical, G became hostile. So the Crown's case therefore became largely circumstantial. And the court had to make use of whether Cooper had elected not to testify. So we've got a hostile complainant not telling us much. We've got a situation when there's only 2 people in the house and Cooper doesn't give evidence. So can the court make something of the fact that Cooper fails to come and tell his story? The accused, someone struck the wife. The accused know who struck the wife, and he didn't controvert that statement to police, or her statement originally that he struck her. And the court said, without doubt, based on accident, there was no suggestion that it may have been an accident. There was no suggestion that it may have been consent or in self-defense. In that case, the court said, yes, this is one of the exceptions, and we think it does warrant a Weissensteiner direction as opposed to the standard as a party comment. But courts do restrict the Weissensteiner direction to give an idea of the extent to which those directions are restricted. Have a look at the case of Dyer, D-Y-E-R, against the Crown, 2002, 210 CLR 285. This was involving some sexual assault matters of a 13-year-old girl who was previously 11 at the time. There was some entries in a diary, and the defendant didn't call any people as witnesses. In that case, the court said, no, a Weissensteiner direction is not appropriate. To expect the defendant to call evidence denies that prosecution is able to prove its case beyond reasonable doubt. And the jury should not speculate about the evidence that might have been given by those people who were not called. Now, some commentators, Professor Forbes, John Forbes, says that Dyer overrules the decision of Weissensteiner. I don't go that far. I say that Dyer is an example of how the court considered Weissensteiner but indicated that the normal rule, that is, as a party, should apply in that particular circumstance. So in my view, Weissensteiner is still potentially good law, albeit that it is the exceptional circumstance. Now, just a quick yes or no, just to keep you active. Have I confused you with this discussion around Weissensteiner and as a party? Confused? No? Well, that's good. No, no, no? Okay. All right. Well, good work. Good work. So it's important that from an exam perspective that you're able to explain the difference, talk about the source, give a brief explanation as to what the rule means, explain what is the usual situation, explain what is the exceptional situation, and have statutes, if there are any statutes, and I don't think there are, but have cases to support your propositions on all of these things. All good? Okay. Well, you've been very patient and it's been a long day, I'm sure. So we might wrap it up at that stage, or at this stage. Does anyone have any questions, comments before we break for Christmas? All good? Yes, Michael.
John, are we getting a Christmas gift or about our marks, or are we waiting till the new year?
I'm very close to being able to provide the marks, and I do hope that I'll be able to, but I'm catching up with family from tomorrow for the next 4 days, so it'll be a matter of me trying to find half an hour or an hour to release some results. So I will get those results to you as soon as I can, but it's just things get in the way. Sorry. All right. Any other questions? All right. Well, thank you very much for your attendance. Obviously, next week is a holiday week, and from there, over the next few weeks after that, we may have some recorded sessions. I'll let you know if I'm cancelling a live session to replace it with a purely recorded session. But in the meantime, please question and answer. Make sure you look at that level 3 video so you know what I'm talking about when I say you need to prepare this to level 3 standard, and we'll see you in a couple of weeks. All the very best. Bye then.